some of what we have to do on the left side of the EDRM model is advise people about what they have to, or what they can say, what they should not write, what they should not say. Basically, people should treat social media as if it were any other business communication. There should be some formality to it. There should be a business purpose. It shouldn't be full of OMGs and other shorthands for communication. And so some of the things mentioned before with other methods like email that was dealt with in Enron, you don't want to be using words like stupid, huge mistake, big mistake, dumb, shocked, speechless, too late, uncomfortable. I don't think we should. These kinds of words simply don't belong to business communication. And if people get it through their heads, and they will, because they did it in the paper world, they did it in the email world, we can do it in the social media world, and we can do it in the next form by which people communicate. Just eliminate those forms of language from your methods of communication. So the bottom line is, if you get involved with litigation and you don't find that the client already has a code of conduct for dealing with this data, have them adopt one immediately, and at least for communications on a going forward basis relevant to litigation. They will be less embarrassing than those that preceded it. People need to know that even though you're texting and tweeting and going to social media forums, you cannot communicate about confidential information, whether it relates to a customer, a patient, or a client, in any way that will allow an intercepting party to be able to determine about whom you're speaking. So basically people have to recognize that this is a mode of communication which can be intercepted, can be reposted, retweeted, whatever. And if there's identifying information in there, it can create liability situations for you. Good rule of thumb, in addition to all business communications on social media shall conform to the company's ethics standards, is to separate, have your people separate their business and their personal social media sites. It won't always happen, and people will often communicate on whatever page is open at the time, but to the extent that people can be encouraged to separate the two, it will make their lives easy, make our lives as attorneys easier, because we'll have only one as opposed to multiple sites to collect from. And the other thing that everyone using social media ought to be aware of is understanding the privacy settings and what they mean. How much is really protected? The courts that are dealing with this, and we'll get into that in a moment, are generally taking a view that if you can show some reason for disclosure, that disclosure will occur. If it's not privileged, if it's potentially relevant, it will come out in discovery.
When you talk about setting an appropriate corporate policy regarding communications, do you mean communications from the company's equipment, or is that policy supposed to expand to what they do at home, or the device they bring to the office with them? It's not owned by the company.
I think the way to look at it is the content of the communication. If it's business related, it ought to be governed by these standards. So whether, as you say, people use personal devices, sometimes employers don't supply the devices, sometimes people have supplied devices and a personal device. People will communicate with whatever is closest at hand when they want to communicate with someone else. So the focus really has to be not so much on the device, but on the content.
I think that's a good question, and I agree with Gordon. But listening to this idea of conforming your Facebook communications to the company policy, making it, if it's a business communication, make it a business, more formal type of message, I think is difficult, because one of the reasons why companies are using social media to subtly market their products or expressly market their products is to be cool and to be different, and to connect with the younger audience. And the more that you make that, or you as a lawyer come in and tell your client, listen, you've got to clean this up, a lot of them won't like that, because especially like smaller startups, I mean, their business is being driven by this, and they want to aggressively market at all costs. So I think it really depends on what your client's tolerance is for the risk, and as lawyers, both inside and outside, we need to advise them of the risks if they allow their employees to really, get too close to the line of what's appropriate and inappropriate.
I agree with that completely. I was focusing on that which is regulated by existing statutes. That kind of communication needs to be the more formal standards.
Right.
You're absolutely right with guerrilla marketing and everything else that the social media is being used for. Context is everything, and that's really what we have to be alert to.
What I was more referring to was a case like American Medical Response in Connecticut, where they had a policy in terms of behavior. The woman gets angry, she goes home, and on her personal computer, blasts her manager on Facebook. I'm sure you've heard of it. Blasts her manager on Facebook. The National Labor Relations Board said that was okay. So even though it was against policy, but I guess the NLRB is saying you really can't regulate what the employee is doing, I think, away from the office and on their own equipment, I think is the point.
Right, and I think that's a different focus than what I'm addressing, which is business content and the use of the new media to expand the way business messages are contained. You're addressing a completely separate and totally appropriate concern that management has. Management doesn't want employees, in effect, blackballing them to the public. It's the downside of guerrilla marketing. Your own employees can be your worst enemies, and the NLRB in that situation is saying there is a privacy consideration. There's also First Amendment considerations, and the employer can't override privacy to the extent it's not regulated by their standards or First Amendment rights. So that's just a different issue that arises in the social media context.
Steve, let's move on to the next slide. So I tried to put together a slide that reflects where we are and where we're going. On the left side, this is kind of now, what's happening now, and on the right side is where it's going in the future. Recognize, though, that all these things are happening now, but I think in terms of a trend, this is how I see it. On the left side, bottom left, you have witness and juror research. This is happening all the time. Before you depose a witness, before you cross-examine a witness, you send your computer-savvy first-year associates or whatever to the public internet and try to find as much dirt as you can. If the information is public and you don't use subterfuge to get it, it's totally fair game. Juror research, which Gordon mentioned. In the District of Delaware, for example, you receive a list of the potential jurors in the pool 3 days in advance of voir dire. Jury consultants and their researchers take those lists, and they have teams that scour the internet. Whether it's the Alumni Association, where you've posted all your updates and your education background, Facebook, anything from Yelp. I mean, it's across the gamut. And you learn stuff about these jurors before you actually have to question them. So that is happening. Now there are rules, and we'll talk about where you can cross the line and what is fair game. The next box over is relevant to a specific issue. And the judge mentioned one this morning, the case where the plaintiff was arguing that they had a loss of enjoyment and they had become disabled. And it was a personal injury case. And sure enough, on the publicly available social media, there were photos of this person riding a horse and fishing, and there's all this stuff that contradicted the sworn testimony. And so it became very relevant to a particular issue, and the court compelled production. Continue to move over. You have social media just being treated as typical ESI. Now, I think ultimately that's where we are and where we should be, but I think a lot of lawyers now and in the foreseeable future will try to treat social media as a lot of us have treated instant messages, Blackberries. You kind of just, it's mutual assured destruction. You just kind of look away and don't worry about it. Or you try to stipulate around it craftily by defining what sources will be collected from a custodian. You limit it to, network-based emails, locally stored documents. You craft it in a way that, subtly exempts from that these unique ways that people, share information. But I think one of the main takeaways is that we, as people who are interested in these issues, need to convince others in the industry that this isn't going away, and we need to treat it as typical ESI and build into our systems and our preservation plans, production plans, ways to deal with this. And then on the far right, you're going to have litigation specifically about social networking. The manager who sends an inappropriate message to an employee and results in a harassment claim. The Lanham Act violations for false advertising because of over-aggressive use of social media. I think there will be a bunch of litigations. There already are, but there will be more litigations about social media in the future. Now, if we turn to the next slide, I thought this was a very useful quote from a case in Pennsylvania. The scope of discovery into social media sites requires the application of basic discovery principles in a novel context. That relates to the third box I was talking about. Yes, it's different, but ultimately, if custodians, clients are using social media for business purposes, it will be the subject of discovery in the case. It may go before a court, and the courts are doing what the judge said they do, is they fall back on what they're comfortable with and how things currently work. So we need to apply normal reasonableness standards, reasonable and good faith standards to social media. So the next slide deals with what I just talked about, the practical approach by courts. If it's a fishing expedition, the court will probably not allow it. If it's targeted to specific issues and you have a reason to believe it's relevant to the case, the court is more likely to grant the discovery. For example, if there's public information that is readily available and you can attach to a declaration in support of a motion to compel, that might pique the judge's interest. So if there's that hook, it might allow the judge to understand there are more, maybe more private information that you would typically think of as personal stuff that is subject to discovery in the case. And it's a real interesting question on, whether that kind of private information is within the possession, custody, and control of a party. And this is an issue we deal with a lot. The bottom line is that private information is not off limits, as much as your employees would like it to be. And the user or the party may be compelled to produce what they thought was private in the litigation.